Hello, everyone, and welcome. We thank you for joining us today on Level Up Law, where we are leveling up your legal knowledge on the different areas of law that we practice here at South Carolina Legal Services. I'm Susan Ingalls, Senior Staff Attorney, and I'll be the moderator of the webinar today. We're delighted to have with us our Elder Law Unit Head, Taylor Ott, who practices out of our Orangeburg office. The subject of Taylor's presentation today is, Are You Prepared? What you should know about wills, powers of attorney, and probate. Please note that the webinar is being recorded. Participants will receive a recording and a copy of the slides, and they'll also be posted on our YouTube channel. So, Taylor, take it away.
Good afternoon. My name is Taylor Ott. Like Susie said, I am a staff attorney with Legal Services. I am the Elder Law Unit Head, and I work in our Orangeburg office. So today, when we were trying to figure out what to address with elder law, because it is really a large area of practice that deals with any issues that our older clients may have, one of the things that floated to the top was advanced directives. So I know that the title of the webinar also includes probate as well, but probate administration is a really big area of law. I'm happy to take questions about that at the end, but the webinar will primarily focus upon advanced directives. So we'll get started. So one of the things to note first is just some general information about legal services. We have 9 offices around the state. We cover every county in South Carolina, and we're a statewide law firm, so we have the ability to coordinate with other offices. So if you have a legal issue in South Carolina and you're eligible for services, we may be able to assist you. So as far as who is eligible for legal services, we do have some income guidelines for where we provide services to people who are within 125% of the federal poverty level, but we do have grants that allow us to assist our older clients with certain legal issues where those income guidelines might not come into play. We do also have limitations on the assets that our clients may have, and then there's some exceptions as far as how we can represent clients who might be outside of our normal financial guidelines. If somebody is eligible for legal services and they're have a case where we would take within our priorities, there's no cost for any work done by a legal services attorney. However, if we are filing a court case, clients would be expected to pay the cost of that court case. One of the examples when it comes to advanced directives would be the recording fee for some of the documents that we'll talk about today. As far as how to apply for legal services, we have what's called Lattice, or the Legal Aid Telephone Intake System service, and that is open Monday through Thursday, 9 a.m. to 6 p.m., and the telephone number is 1-888-346-5592. You can also apply through our website, which is sclegal.org, and under most circumstances, you can also apply in person in your local office, but that would be something I'd encourage you to call the local office before you appear in person to see how they might be able to assist. There are certain type of cases that we don't take. In general, the big ones would be criminal cases or fee generating cases. We have a number of different areas of law. Some of the areas that I practice in are family law and employment and elder law, as you can see. So when we're getting into advanced directives, the big thing to understand is that in general, these are legal documents about how you communicate your wishes about what you want to have happen. The ones that deal with healthcare would be expressing your wishes about end-of-life care, and then with a last will and testament that directs what you want to have happen to the things that you own after your date of death. So it allows you to express at a time when you have capacity and the ability to think and you're not under pressure what you want your wishes to be. So there are a number of advanced directives that we're going to talk about today. Living will, there's several different types of powers of attorney. There may be some misinformation sometimes about powers of attorney. We'll talk about those in a little bit. South Carolina now has what we call post or physician orders for scope of treatment. A last will and testament and trust are not really considered advanced directives, but they are within what we'll talk about today as far as advanced planning. We will not be talking about trusts. So when we ask the question of who should create an advanced directive, the answer is everybody. Everybody should have one. One of the things that happens when I do these presentations is I'll kind of take a poll of the audience of who does or does not have an advanced directive. And regardless of where I'm giving the presentation or to what age group, I'm actually surprised most of the time by how few people may have had any advanced directive. And then I start asking questions about how many people may have had difficulty with a loved one who was at the end of their life as far as what decisions to make on behalf of that person or what to do with the things that that person owned after their date of death. And then you start seeing those hands raised in the air about where they had experienced with a close friend or a dear loved one about how to try to figure out in difficult circumstances what that person may have wanted. So that's the main reason to have an advanced directive, is to let your loved ones know when you're, again, clear-headed and have the chance to think about it, what you want to happen after either the date of your death or your end of life healthcare. So one of the things that South Carolina has is what's called a living will. Sometimes you'll see these referred to as, and actually have the title of a DNR, or do not resuscitate. There's also something that went around for a long time called the 5 wishes. It was frequently a document given out by life insurance companies or sometimes funeral homes. And those were statements about what you may have wanted in your hospital room at the end of your life, what type of funeral service you may have wanted. Those are different than what we're talking about today. So with a living will, you are expressing to your physician, your family members, what you want when it comes to being in a terminally ill or permanent vegetative state. There's a standard form that we use in South Carolina, and the documents that I talked about as far as the 5 wishes and the DNR don't necessarily always follow the format that we use in South Carolina. In that form, it asks whether you want artificial nutrition, hydration. So one of the benefits of having a living will is that state law requires that it be followed as far as if you want life-sustaining treatment to be withheld. So if you don't have the ability to make medical decisions on your own behalf, and you don't have any advanced directives when it comes to healthcare, what will happen is they're going to have to figure out how to make those decisions for you. Your family members, your friends, your physicians are going to have to figure out the best means of making those decisions in line with what you may have wanted. One of the things that they may actually pursue is what we call guardianship in probate court. And that's not something we'll talk at length today unless there are questions about it. But that's where the court appoints a certain person to make medical decisions on your behalf. And that may not be in line with what you would have wanted if you had had the opportunity to create and state your wishes in a living will. So this is a better alternative than having to go to court about who should make medical decisions for you. And it helps your loved ones and your friends in a difficult time already when they're under stress to know what to do. You may not be able to express or make reasonable medical decisions on your own behalf in certain circumstances. And so it gives them some direction or statement about what your wishes are. So the next thing we're going to talk about is a healthcare power of attorney. Again, this is what we call a statutory document, meaning the legislatures in South Carolina laid out the specific language that has to be included in the healthcare power of attorney. So here we are naming what's called a healthcare agent to either make medical decisions on your behalf or let the doctors know what your wishes are. And so here we will name a primary healthcare agent and 2 alternates. And the document, it has 2 pages of instructions on the front of who can and cannot serve as a witness for the healthcare power of attorney and also who can't serve as an agent. One of the difficulties we have with these documents is the fact that sometimes they are done in the hospital setting, which is fine, but treating physicians, nurses, anybody else on hospital staff or that could possibly be involved in medical care cannot serve as an agent or serve as a witness in this document. So it's going to take a little bit of forethought and planning to make sure you have the right people around to witness this document and serve as the agents. In this document, the agent will be given access to your medical records. So normally when you go to a physician's office, you'll sign a HIPAA release, allowing the physician to communicate with or transmit your medical records to someone other than yourself. So you would say you wanted your spouse or your child to have access to your records. One of the specific things this states, actually on the first page, is very specific language stating that this agent will have access to your records just as if you had listed them on that HIPAA release with your doctor's office. And then on the second page, it goes into really detailed explanation of how this person, if you give them the power to make medical decisions on your own behalf, can actually make any medical decision you'd be able to make for yourself. So it's an exhaustive list of what medical decisions they could make on your behalf. You have an opportunity to limit their ability to consent to certain types of treatment or any limitations you want to place on their powers in the document. So one of the things to think about before you are putting this document into place is, who do you think is going to make good decisions on your own behalf or enforce the decisions that you may announce in this document, but also who's going to be available, who's going to be around and accessible to physicians. We include contact information for the agents in the document, but you want to make sure that you have somebody who is involved in your life and is going to be available for them to have access to the physicians, to communicate with them and express your wishes. This is not something that has to be recorded. So a healthcare power of attorney goes into effect the date that it gets signed and properly witnessed. You want to provide a copy of that to your physician so they know exactly what your wishes are. The living will also does not have to be recorded. At any time that you want to revoke or undo those documents, there's a number of ways. Actually, it'll state in the living will has explanation at the very end of how you can revoke them. I think it's also present in the healthcare power of attorney as well. But you would either revoke them by destroying the original and any copies of the healthcare power of attorney, as well as letting your physician know that you no longer want to have that healthcare power of attorney or living will in place, or you let the agent know. So the healthcare power of attorney is pretty broad and has a lot of power in it. And the difference between the healthcare power of attorney and the living will are, do you have someone that you can name to make your medical decisions for you? So if you're in a place in life or physically distant from family members, but you want to express what your medical wishes would be at the end of your life, or if you were in a permanently vegetative state, if you don't have somebody to name, I'd suggest that you go with a living will. If you do have someone that you can name and the doctors can contact, that's when it makes sense to have a healthcare power of attorney. So the benefits of a healthcare power of attorney is that someone with, I'm sorry, I'm looking at the language in the slide. It's a little bit confusing. So in order for life-sustaining treatment to be withheld from someone, they must have a living will, or what we call, a do not resuscitate, a DNR, on file with them. If you were unable to consent to medical treatment because of your illness, you would have to appoint an agent to enforce or revoke your living will. So this is a little bit confusing. So we'll move on to the next slide. So the big thing here is you don't need both. The healthcare power of attorney is broader, gives more power to who you choose as an agent. And if you do choose to have both, you want to make sure that they're consistent with each other. Because if they're inconsistent, then the living will actually trump the healthcare power of attorney. So you may name a healthcare agent in your healthcare power of attorney who is allowed to have total decision-making on your behalf when it comes to life-sustaining treatment, artificial nutrition, and hydration. But your living will says you don't want either of those if you're in a permanently vegetative state or terminal. In that situation, the agent would actually have to follow what's in the living will. So you want to make sure if you are thinking about doing either one of these documents, you need to figure out first, have you ever done either one of them before? And if you have, you need to consider possibly revoking or undoing one of the former documents that you've gone ahead and done so that your wishes are either consistent or you're now moving on with a different set of decision making. When you're considering who should be your agent, and this is both true in a healthcare power of attorney and in a normal power of attorney. When you're thinking of a healthcare agent or an agent, which used to be called an attorney, in fact, you want to think about someone who knows what your wishes would be. And so sometimes if you have more than one child, that might be picking one child over the other. It might be avoiding the family issue altogether and picking a trusted friend or maybe more distant relative. But when we're talking in the healthcare power of attorney, one of the things that you can indicate is you want the agent to make decisions on your behalf about end-of-life care or artificial hydration and nutrition, taking into consideration conversations you've had with them, your wishes, the cost of treatment, the likelihood of recovery. So if one of the things the person is supposed to take into consideration is what your wishes are, who's going to listen to you? Who's going to actually follow through with what you have talked to them about, how you may have expressed your wishes in other ways? So you need to pick the person who is going to be able to have the ability to follow through with your decision making, even if it's under difficult circumstances. And so it may make sense to choose somebody who you know is not going to be emotionally vulnerable at that time or under an extreme amount of stress if you were going to be terminal or in a vegetative state. You don't have to pick a spouse or a close family member, but you do need to make sure, like we talked about earlier, that you're picking somebody who is readily available to healthcare professionals when the time comes around for making those decisions. So if you don't have an advance directive, so if you don't have a will or a healthcare power of attorney, what happens? There is a number of things that you might put into play that can help with this. So there's what we call the Adult Healthcare Consent Act in South Carolina, and that allows, as explained here, a priority list set out by state law of who can make decisions on your behalf. And so that starts with if you are married, it's your spouse. Then if your spouse is deceased or you're divorced, then it's your adult children in no specific order, and then it goes out to certain distant family members. But if you have done healthcare power of attorney and you name an agent in that document, that person would have first priority under that law, but also power under the healthcare power of attorney to make those decisions for you. So sometimes I get the question when I do these seminars about what if I haven't seen my spouse in 20 years and they suddenly appear at my bedside when I'm terminal or in a vegetative state? Can they make healthcare decisions for me? And unfortunately, the answer is yes. Certainly, there are ways around it. You can then take a case to probate court where we go through that guardianship process we touched on earlier, where the court would decide who's the most appropriate person to appoint in a guardianship action to make healthcare decisions for you on your behalf while you're unable to do so. But certainly that one can imagine a situation where a spouse that you have not had contact with, or you're not formally divorced, coming in and making medical decisions for you, or at least having access to records that you would not want them to. One of the first things I do with my family court clients, if they're separated from their spouse, is we talk through advance directives so that that very situation doesn't happen. Going ahead and appointing a child or another family member as a healthcare agent so that we're not having the situation where an estranged or possibly abusive spouse is going to have the ability to make medical decisions or have access to records. And you can all imagine the situation of family members weighing in when it comes to the Adult Healthcare Consent Act and how difficult it might be for a physician to figure out who really has your best interest at heart. And the way around that is by having an advance directive. So South Carolina now has what we call a physician order for scope of treatment. And that allows the physician to make a note in your electronic medical records about who you would want to make decisions on your behalf after you've been diagnosed with a more serious illness. So this would be, we have an idea of what your longevity would be, or like we know that you're possibly terminal or you have a serious illness. One of the things your physician can make a note in the chart about is what your wishes are. So some of the same information that you may find in a living will or in a healthcare power of attorney could also be contained in your medical records. It can work together with your other advanced directives. And the neat thing is that it's portable from one physician to another. So when your chart gets transferred, you go from your general practitioner to inpatient to the hospital. That physician order for scope of treatment will cover it as well. So then we get to powers of attorney. So there are different types of powers of attorney in South Carolina. So there's the one that we've already talked about, which is the healthcare power of attorney, where you're naming an agent to make decisions for you. And then there's what we call a durable power of attorney and a limited purpose power of attorney. Those are the two that we're going to talk about briefly right now. So with the durable power of attorney, that would be something where you are giving an agent, or what used to be called an attorney in fact, the ability to make decisions for you. It goes into effect once it's properly recorded in the same office where deeds are recorded for in the county that you live in. So sometimes that, like here in Orangeburg, that would be the Orangeburg County Register of Deeds. In Aiken, it's the Register of Mesny Conveyance. Barnwell is the Clerk of Court. So the thing here is you are naming who is going to provide different types of assistance to you, or these people who have the same powers you would if you were able to go out and do things for yourself. So sometimes durable powers of attorney will include healthcare provisions as well. So sometimes I'll review documents that are done by another attorney, and maybe we're helping with a revocation of that former power of attorney. You'll frequently see really broad financial scopes in the powers of attorney. So that person is allowed to conduct banking on behalf of my client, allowed to open and close businesses, mortgage any property they may own. It could be really broad, and then it also includes a healthcare provision. The big thing there is, I at least notice in my own life, the person that I would name as a healthcare agent is completely different than the person that I would want to make financial decisions on my behalf. And I think that's a consideration when you're doing a power of attorney and considering appointing somebody as an attorney in fact or an agent. You want to consider, could this person make both financial and medical decisions that are in my best interest? So powers of attorney go into effect when they're properly recorded. There are certain what we call formality requirements, and those have to be signed in the presence of two witnesses, one of which would also sign in the presence of a notary public that they witnessed your signature, and they have to be signed at the time when you are considered competent. So that's one of the big things when it comes to advanced directives is the person aware of what they're signing? Do they know the powers that they are giving to the person named as the agent in the document? And so one of the things that we take into consideration when we have a client come in for an advanced directive is, first, do they need it? I'm not going to do, especially not a durable power of attorney, I'm not going to do those unless the client can express to me why they need them. So I'll do healthcare power of attorney and a living will if the client has the medical need for it, or we're doing it as pre-planning. But at least in my own personal opinion, powers of attorney are, especially really broad ones, are most of the time unnecessary for most clients. And when I am preparing those for a client, we make them as specific as possible. So if all my client needs is assistance with banking, well, the first thing we talk about is, can you add that person as a signature, like a signatory on the bank account, to have the ability, not as a joint tenant on the bank account, but is there something we can do on the bank side to provide the client with the assistance that they would need, rather than giving that person the ability to do all of your banking? Because what's to keep them other than the duty to act in the interest of the person they're acting on their behalf of. Other than that, what's to prevent them from opening a bank account, transferring it? You know, certainly we have protections in the law for someone who is taken advantage of as the result of a power of attorney, but it's really hard to prove. It's something that I always ask specific questions when somebody comes in. You know, why do you think it's necessary for you to have a power of attorney? Is there any other way that we can achieve the goals that you have other than doing this document? So that's the bottom line on the slide here is this a document that you really need? Because it goes into effect when it's recorded, and it lasts for your lifetime or the lifetime of your agent, or until your agent is incapacitated themselves, or until you file what we call a written revocation. So unlike with the healthcare power of attorney or the living will, you can't just tear up the document and tell somebody you no longer want to follow it. You would actually have to have someone prepare a revocation for you. And in that, you formally state you no longer want this power of attorney to be in place. You want to revoke it. We cite the date that it was signed and the page number where it was recorded, and we file that at the Register of Deeds or the Clerk of Court, wherever it may be. And because this is what we call a durable power of attorney, it goes into, and the assumption in South Carolina is, it goes into effect as soon as it's recorded. So this isn't a rainy day document that you have laying around that you get recorded that you use when you need it. It means that as soon as you leave the Register of Deeds with a copy of the recorded document, it can start being used. So all that to say, as you probably can tell, it's a really powerful document. So you should consider using it with caution. And it's probably not something that you really need, but there are certainly circumstances when it is necessary. So it's a powerful document. There are other alternatives, like we talked about a little bit. You could have, if you think that you need somebody to go and have contact with Social Security Administration, you can name somebody as a rep payee on that document. There's a way of, with Veterans Affairs, naming a fiduciary for any pension payments that you may have. We've already talked about the healthcare power of attorney and the Adult Healthcare Consent Act. We briefly talked about the authorization form for HIPAA. So that would be if you think somebody just needs to have access to your medical records and you want them to be able to have access to those and use those the same way you would, you can sign a HIPAA release. And then there also would be guardianship and conservatorship that could be filed on your behalf if necessary. So if you became incapacitated, you're unable to understand your financial situation or make reasonable financial decisions on your own behalf, what would happen is somebody would need to have a conservator appointed on your behalf in probate court. And that's something that can be done relatively quickly, at least if there's an emergency. And then the court is going to be really careful about who they appoint as the guardian. They're going to get a background check. They're going to get a credit check. They're going to have a hearing about who should be appointed on your behalf. And it's not automatically going to be whatever person applies for the conservatorship. The law lays out who should be appointed. And again, it starts with whoever you're legally married to. But if you have a healthcare power of attorney or another, what we call advanced directive, like a power of attorney, that person's first in line to serve. So if for some reason you did a durable power of attorney and it's not broad enough to cover the particular issue that you're having at that time, that agent or attorney in fact could go to the court, petition for a conservatorship or guardianship, and if they're fit, would be appointed by the court first in line ahead of anybody else. So like we talked about a little bit, you have to have the necessary capacity to execute a power of attorney. You would have to have what we call contractual capacity. And so that would be that you have the ability to understand at the time that you're signing the document, what you're signing and what the effect would have. The capacity has to be present at the time of execution. So one of the things that we will also help people with is sometimes trying to challenge or undo, if possible, an advanced directive they may have signed, and that person may have a diagnosis of dementia, Alzheimer's, some other type of progressive illness, and what they would have to convince a court of is that on the date and time they signed that document, they didn't know what they were signing or the effect it would have. So that can be really difficult to show. You may even have gone to a doctor that day, have a medical record that shows that you had capacity. Well, if that doctor's appointment was at 9 o'clock that morning and your appointment to sign the power of attorney or contract was that afternoon, certainly we know that given those progressive conditions, people will have a period of clarity where they understand and they very much themselves, but that doesn't last. So sometimes that's for days or months at a time. Sometimes it'll be hours. It could possibly go away in between those two appointments. Capacity is fluid and can change. So that means that sometimes clients may not be completely able to answer all of the questions I would ask when it comes to capacity. So asking them to remember certain phrases and repeat them back to me, asking about current events and seeing if they're oriented to place and time, asking them to give me demographic details or family history I may be aware of, that they may be able to answer that better on one day than another. And here we have to have a higher capacity than is necessary to sign a will. And we'll talk about that in just a minute. So with a last will and testament, or sometimes referred to as just a will, this is a document that you provide instructions for what should happen to the things that you own after your death. So this would not, if let's say you own a piece of property at the time that you're doing your will. At the time that you pass and your will is presented to the probate court, they're trying to figure out what assets would go through estate administration. If you had sold that home and the will talked about it, it's not going to be something that's going to be included in estate administration. So it doesn't undo any other what we call inter vivos or lifetime transfers of property. The court would only consider your assets to be controlled by the will would be things that you own at the time of your death. So why would you need to consider having a will? So here it makes sure that your things that you own at the time of your death would go to the people that you want them to. So you could say who you want things to go to, how much each one of them would get, and then directing which pieces of property or personal property would go to those heirs. So this allows you to leave shares of property or things to people outside of your immediate family or to possibly a nonprofit or another organization. What happens if you don't have a will is that you would be declared what we call intestate, and they would use the court would use what's called the intestacy statute to determine who are your heirs. So if you have a will, you can name whoever you want to receive property or assets after your death. Those people would be considered your heirs. And that could be anybody. You could give, this wouldn't be effective, but you could give the moon to your niece in your will if you wanted to, and she would be identified as an heir. With the intestacy statutes, it is going to say certain family members in degrees of relation or how closely related they are to you is going to get a set percentage of the property. So an example would be if you die without a will, you are going and you're married, but you don't have children, your spouse will get 100% of what you own at the date of your death. If you are married and you have children, then it would be 50% to your spouse and the remaining 50% divided between your children. And so that may be 25% to 2 children. Obviously that percentage gets lower and lower the number of children that you may have. So you have a lot of power that you can exercise when you do a will. You do not have the ability to absolutely leave a spouse out of a will. What that means is you can say in your will that you don't want them to inherit. They may have some ability, depending on the circumstances of your case, to file a claim against the estate and get some portion. But it does allow you to prevent certain immediate family members from inheriting from your estate, again, the things that you would own close in time to your death. So again, that question about spouses comes up. So you die without a will, and you may have filed a divorce case or a separation action in family court. You never actually got divorced. That spouse would inherit from your estate if you didn't have a will. Those intestacy statutes will leave a portion of your estate to your still legally married spouse. And here also with children, if you don't have a will, only your legally adopted or biological children are going to inherit from your will. So if you had a child that you raised but was never legally adopted and was not your biological child, unfortunately that person is not going to inherit from the estate if you don't have a will. So your personal representative is someone named in your will to be responsible for filing everything with the court after your death. So far when we've talked about a healthcare agent or a durable power of attorney, we've used that word agent or attorney in fact. So here it's the same, it's a similar role. It's called a personal representative, and they make sure that your wishes are followed after your date of death. They have to take the original will to the probate court after your death, and actually can do that no sooner than 30 days. There are certain fees associated with opening an estate in probate court. Those depend on the type of assets that you owned at your death and their total value. We want to consider doing a new will when we have major life events. So that would be divorce, death of a spouse, remarriage, birth or death, possibly death of a child. You would want to make considerations of totally redoing a will at that point. So the capacity necessary to have a will or have one that's validly signed. You have to be 18 years of age or older, have to be of a sound mind, recognize what you own and who you want to leave that property to. So you have to be able to identify who you want as your heirs and identify the assets that you have. So we have already covered all of this. This is what happens if you die without a will. And the bottom line is if you don't have a will at your date of death, the probate process becomes longer and more costly, because if people are fighting over who should inherit what or who should serve as the personal representative, the court's going to have hearings on those. There's usually in most counties a $150 filing fee that they will charge for every hearing, and it may be something where the court makes a decision about who inherits from your estate or serves as the personal representative that are different than what you would have wanted if you had a will. So the original will has to be filed with court, the probate court after your death, and the personal representative would have to list in a document what they estimate is the value of your estate and indicate whether or not it included real property or real estate. There's a process called a small estate affidavit, which allows if you have personal property, so no real estate, but vehicles, mobile home that's not tied down to a piece of land. If the total value of that estate is less than $25,000, then you could use that process. You do not have to leave the estate open for the required time period for creditors to file against it, so it's much quicker, and it's a 2-page form that you file with the court. And that would, again, follow the instructions in your will as to who should inherit personal property from you. If you don't have a will, they'll use the intestacy statutes. With a full estate, if real estate is involved and or the total value of the personal property in the estate is greater than $25,000, you use full estate administration. And you have to open the estate within 10 years from the date of death. If you don't do that, so if somebody passes and they had a valid will at the time of death, if the estate is not opened until 10 years after that person's date of death, you can no longer use any estate administrative process and the will effectively becomes invalid. You would then have to file what we call a petition to term in heirs action, where you would have to show to the court at a hearing who is related to that person, providing documentation to show marriages, deaths, births, divorces, and true certified copies of all of those forms. It is a lengthy and expensive process. So if you hear one thing that I say today is that if someone passes, especially if they own real estate, make sure that somebody administers that person's estate in probate court, regardless of whether or not they had a will. It's going to cause a problem with the title to the real estate and how people can actually use that property. So once you have signed your advance directive or your will, here are just some kind of talking points on these. You're going to make sure that your will is kept The original is kept in a safe place. I have occasionally made photocopies of wills when clients ask for them, but my general rule of thumb is the client should walk out of their appointment with an original, and that other than the copy I keep for my file just to make sure that we have a record of what we did for them and the services we provided, you want to make sure that copies are not made, simply because the court cannot accept copies when the estate is being administered. So you want to make sure your personal representative, the person who's responsible for filing the will and other documents after your death, knows where the original is. So it would be a good point to keep all of those documents in the same place. So if you had life insurance policies, original documents of other types like death certificates and things that might be important, and other valuables, you want to keep those possibly all in the same place. With a durable power of attorney, for it to be valid, it has to be recorded in the same office where deeds are recorded for the county that you live in. So if you have one sitting around and the time comes for it to be used, if it's not actually recorded, it has no use. But certainly there are circumstances where a client will sign it, and this is not my practice, but where someone will sign it and not have it immediately recorded, and then it gets recorded where it needs to be when that client has need of it. But what if you don't know where it is? What if you're incapacitated and you can't tell someone? So I usually advise clients to go ahead, I will regularly help them record the document themselves, but it certainly can't be used until it's recorded. And then you want to give your agent, or formerly called an attorney in fact, a copy of that recorded power of attorney so that they know exactly what powers they have and that you've appointed them. When it comes to healthcare powers of attorney and living wills, you want to make sure that a copy is given to your agent or your physician. And with this, the original, a doctor can accept a photocopy of the healthcare power of attorney or the living will and follow it. They don't have to be presented with the original. The reason to keep the original in a safe place or to tell your agent where it is because destroying the original and all of the copies are one of the ways of revoking those documents. So with revoking an advance directive, all of them have different requirements for being revoked. Sometimes it can be done by having a new document prepared. So a will is an excellent example of that. So let's say a probate court is presented with two different original wills signed by the same person. So let's say they're signed by me, Taylor Ott. One is dated October 1st, 2015, and the second one is dated October 1st, 2019. They will go with following the will that is signed, validly signed and witnessed, closest in time to my death. So by signing that will, that new one, 4 years after I signed the first one, I have revoked or undone that first will. So what that means is every time you sign a new will, you revoke any wills that you've done before that. Usually that'll be the first line in the will itself. I, Taylor Ott, of sound of mind and body, do hereby declare that this is my last will and testament, and I revoke any last wills and testament I may have executed before this date, or something similar to that in the first line. Healthcare powers of attorney and living wills are similar, that by signing a new document, you can undo the original one that you had done. There's also that additional step of being able to tell the physician that you want to revoke the document that you had done before. The big one that requires an extra special step where I would absolutely advise that you consult an attorney is anything that is called any type of power of attorney or durable power of attorney limited, whatever it may be. That is something that likely is going to need to likely going to have to have that revocation of the power of attorney filed in that same office where the original was filed for it to be formally revoked. So the takeaway at this point is advance directives are important. It's part of a way of communicating to your loved ones what you would have as your wishes to be followed before the time comes when you're unable to communicate that for yourself. I think it is an important thing to have regardless of age. So I give the same presentation to my older clients that I would if let's say I'm doing a presentation about the divorce process or something else in family court and my clients may be relatively young. I will still give that that same presentation and that same push for them to consider having an advance directive. And one of the reasons that you want to have consultation with an attorney before you follow these documents, even though some of them are forms that you could find online, especially that healthcare power of attorney, you should consider which is the appropriate document to have signed for you. And then also the law in South Carolina may have changed at the time that you choose to have your advance directive prepared. The information that I've presented today is current as of June 30th, 2020. And so if you are listening to a recording of this webinar at some future date, just be advised that the information contained here is what's current with the law. There have been some changes to the rules about advance directives, namely that now when those documents are recorded, they go into effect, or the assumption is they go into effect when they're recorded. There have been different versions of powers of attorney or different assumptions created by the law earlier. So that's something that's changed even in the number of years that I've been here doing advance directives. So I've had to change how we handle some of those. So there can't be a safe assumption that these rules are going to be the same at the time that you are considering doing an advance directive. So now we come in the time to the presentation. If there are any questions, I think we had one that somebody submitted before we got started, but if there are any other questions, I'm happy to take them.
Okay, Taylor, this is Susie. Here's the first question is, can I provide a handwritten will and have it notarized? And you have 3 witnesses. It would be a supplement to the one I already have.
So one of the things that you can do after let's say you have an original will and you have one of the witness requirements for will is it has to be witnessed by 2 disinterested witnesses. So anybody that you name in the will that would inherit from the estate can't serve as a witness. So let's say you have one properly signed in the presence of those witnesses and the original is available to you. If you're going to make updates to that, it's what we call a codicil. And a codicil is where you make significant changes to your will, changing who the personal representative is, changing what you want to happen to any real estate that you may own. That has to be done in a codicil. Codicil has the same formality requirements that a will does. So you would have to have a witness sign in the presence, the testator sign in the presence of 2 disinterested witnesses, and then one of those witnesses also sign in the presence of a notary public that they saw the original signature. So I advise clients that because a codicil has the same formality requirements as a will, I would suggest just redoing a whole will, because then you can make sure all of your changes are included in the same document so that your personal rep after your date of death doesn't have to look for a will and a codicil. But certainly if it had the formality requirements, the court would consider it as an addition or a change to the existing will.
Okay, and here's the next question. A has a will leaving everything to his spouse B. They divorce and he dies without changing his will. Did the divorce make the will void?
So there are certain things that can happen after you do a will that will void certain portions of the will. So an example that I'd given earlier was if you don't own something at your date of death that you had included in the will, it nullifies that portion of the will. It wouldn't be effective for transferring that property to the heir. Divorces are something that it depends on what the court is presented with. So the assumption would be, you know, who is serving as the personal representative of the estate when they are filing something with probate court would let the court know that person has been divorced since they did the will. But if the court is not presented with that information, there is some way that that the ex-spouse, at least on paper, would inherit from the estate. So a divorced spouse would not be able to file an admitted spouse claim or an elective share against the estate, like if they were left out, because the divorce ends the marital relationship. So it may be that in the initial paperwork filed by the court or filed by the personal rep may look like the spouse would inherit. They don't, because they are divorced. So the only person who would inherit from you under those intestacy statutes or really from your will would be a legally married spouse. So divorced would not, again, be able to file that admitted spouse claim as well. So the easy answer is yes, the divorce would make that portion of the will null and void, but that's one of the reasons to make it easier for the court that in any big life changes that you would update your will.
Okay, and we have a disability rights attorney practicing special education who asks about several clients who will be turning 18 years old. Let's see. They likely would not fall within the Adult Education Consent Act. Is the process the same for an education power of attorney as it is for a regular power of attorney? It seems that there may be some schools that don't accept an education power of attorney and require a complete delegation of rights for making educational decisions.
That's kind of a long question.
Yeah,
So by virtue of legal aid, you have more than one area where your clients may have concerns. And so I actually myself do IEPs, 504s, a little bit of special education advocacy. So one of the concerns that I'll regularly have for when we're doing, regardless of the age of the parent, when we're doing advanced directives, they may start thinking about kind of advanced planning for a child. So as far as the ability of a parent to continue to participate in a child's educational decision-making under the IDEA, don't you love when you say initials for something and then you forget exactly, the Individuals with Disabilities Education Act. So under the IDEA, which is where we get individualized education plans for special needs students, comes from, the student after the age of 18 is given some preference, usually by the IEP team, to direct their educational choices. But if that child is continuing education up until the age of 21, which they might be eligible for in the district's normal education setting, the parent is still an active participant in that and is given some decision making. So the question as far as the Adult Healthcare Consent Act would be, so a child with disabilities may have the intellectual capacity necessary to sign a healthcare power of attorney. I've had that happen before. It depends on the nature of the intellectual incapacity or that child's physical limitation. So most physicians will continue to work with the parent past the age of 18 and give access to records may be necessary for that person to consider getting a guardianship of that child. So up until the age of 18, family court has jurisdiction over a parent's ability to make medical decisions on behalf of the child if someone were to challenge it. It would not be something that a parent would be able to file a guardianship action before the child turns 18 to kind of pre-plan that decision-making process as far as medical or financial. But once the kid turns 18, we can pursue a guardianship or conservatorship in probate court to address the child's need for continued assistance from a parent. And their Article 5, which is the law that deals with guardianships and conservatorships, changed a year and a half ago. And now the court, universally, probate courts in South Carolina have to grant a conservatorship or a guardianship that is as limited as possible. So the child will retain as much autonomy as they can. So we can go in, it's no longer that all of that child's rights are removed because the parent is appointed as the guardian or conservator. So as far as an education power of attorney, I've never done one of those. There are certainly things where we have, there's a trend with adults or children with disabilities referred to as supported decision-making. So that's a model that's used by our Department of Disabilities and Special Needs in South Carolina, where they want to, especially as the child is, and this is actually part of IEPs as well, that as the child approaches the age of 18, we put into place a way for them, once they gain the age of majority, to be able to have people who are involved in them making their own decisions. So we would, if necessary, involve a parent, or certainly a parent in most circumstances, and other family members, social workers, occupational therapists, whatever may be necessary to have that child set up for success when it comes to making those decisions. So that is a long answer, and I don't know that I actually answered the question, but when I'm meeting with a child that's over the age of 18 and they have a parent, because sometimes the parent will contact us about a guardianship or conservatorship. We talk to them about what they think they need, what the child's disabilities are. One of the things that we try to analyze is what is the least restrictive, just like with an IEP, what's the least restrictive alternative or environment that we can provide to this parent. So most of the time they'll come to us and they don't have a need. Well, they may have been told by someone who's not an attorney that they need to have a guardianship or conservatorship to continue to come to doctor's appointments or IEP meetings with the child. So that's not true. It just depends on the individual physician. And if the child can express the desire for the parent to remain in doctor's appointments or other types of meetings with professionals, at least in the area the region of the state that I practice in, I've not had very many issues with the child, as long as, even if they're nonverbal, as long as they can express to the physician that they want their parent to participate, it hasn't been a problem.
Okay, that was a good long answer to a long question, and I'm sure we have more information on that on our website, or they can follow up with further questions. Here's one more question. This is a person who says, I have a grandchild that my son signed the birth certificate, but later found out by DNA that she's not his child. Would she be eligible for benefits? I assume she means through her own estate or her son's, as a biological or adopted child.
So one of the things, if you name whoever you want in your will, like as your heir, regardless of the nature of that person's relationship, if the original will is presented to the court, that person will inherit. The will trumps everything else. As far as intestate proceedings in probate court, like where someone does not have an original invalid will, what would happen at that point would be the court would consider who are the legally adopted or biological children of that deceased person. So let's say we're talking about a parent and a child. If the parent, if there is evidence the court is presented with, a paternity decision, DNA test results, that child should not inherit, the court is going to follow the rule that would say that child doesn't inherit because they're not biologically related. And if they've not been legally adopted, it could also be that maybe that parent has custody of a stepchild. Custody is not legal adoption, and so a stepchild would not inherit. But what can be done is the heirs of an estate can reach what we call a family settlement agreement. It can say, I know that, child A is not, and you wouldn't put this in the agreement, but they would say, hey, I know I'm entitled to inherit, say, a 10% share of the deceased person's estate. I also want this other person to inherit some portion of the estate, so I'm willing to give this percentage of my interest to that other person. That person doesn't have to be an heir. It's what we call a private or a family settlement agreement. So it's an agreement among the heirs, whether that be by a will or intestate succession, who would say, I know I'm going to inherit this, but I want to give voluntarily, freely and fully, advised of my rights, give my share to another person. So that would be a way for, I had this happen in a case in Aiken years ago, where there were a number of children, and there was someone they recognized as a brother who was never legally adopted and was not biologically related to their parents. He was a raised child, had been in the house with them when they were growing up, would not inherit an intestate share of the estate. And I think they would have all gotten 1/6. I think there were 6 siblings. So each of the biological children would have gotten 1/6 of the dad's estate when he passed. And they were willing to give a certain percentage of their share so that the brother or the raised child could inherit a portion of the estate as well. So the answer to that is the heirs can reach an agreement among themselves to modify what a will says and determine who an heir is by reaching an agreement among themselves. So, and certainly like if the grandmother wanted the grandchild to inherit from her own estate, just name her as an heir. Doesn't matter. And you can designate a relationship. So, you know, in my wills, I'll put, I hereby do give, bequeath, and devise X to my granddaughter Taylor. Doesn't matter whether or not she's legally or adopted or biologically your grandchild. You can still designate her as that, can still use that moniker in the will, that doesn't matter. But the way to make sure that someone inherits from you, regardless of the relationship between the two of you, is to name them in will.
Okay, thanks for that answer. I want to thank Taylor Ott for an excellent presentation on advanced directives and other elder law related issues. And thanks to everyone who joined us today on Level Up Law, where South Carolina Legal Services is leveling up your legal knowledge. We would appreciate it if our participants would complete the survey that'll come up when we conclude the webinar. And I do want to remind you that we will provide the recording and slides, and it will be posted to our YouTube channel for South Carolina Legal Services. And also be sure to register for our next Level Up Law in the series, which will be next Tuesday, July 7th at noon. The subject is removing barriers to employment, and that will be featuring our lead attorney for barriers to employment, Tiffany Love. Thanks everyone for joining us. And again, Taylor, thank you for an excellent presentation. That concludes our webinar.